If you're watching this video, you may be in removal proceedings right now, or you may be considering whether to appeal an immigration judge's decision. You might have heard conversations about appeal deadlines, about courts moving faster, about changes to how cases are being handled. And if you're feeling uncertain or afraid, that's completely understandable. Immigration court is one of the most consequential legal processes a person can face, and the stakes could not be higher. My goal today is to help you understand how the immigration court system works, what an appeal actually means, why the timing of your decisions matters so much, and what you need to know to protect your rights. This is general legal information, not advice for your specific situation, but understanding these fundamentals can help you make better decisions and have more productive conversations with your attorney. Let's start by taking a breath together. The immigration court system is complex, but it operates according to rules and procedures that can be understood. Knowledge is protection. When you understand how the system works, you're better equipped to navigate it, and you're in a stronger position to advocate for yourself and your family. First, let me explain the basic structure of immigration court proceedings. When you're placed in removal proceedings, your case begins before an immigration judge. This is the trial-level hearing, where you present your case, where evidence is submitted, where witnesses testify if necessary, and where you argue why you should be allowed to remain in the United States. This initial hearing before the immigration judge is absolutely critical. It's where the factual record is built, where your credibility is established, where legal arguments are first presented. Everything that happens at this level shapes what comes next. If the immigration judge issues a decision against you, an order of removal for example, you generally have the right to appeal that decision to the Board of Immigration Appeals, which we call the BIA. The BIA is an administrative appellate body within the Department of Justice. It reviews decisions made by immigration judges to determine whether those decisions were legally correct. But here's what's crucial to understand. The BIA is not a place where you present new evidence or tell your story again from the beginning. An appeal is a review of what already happened at the immigration judge level. The BIA looks at the written record, the judge's decision, the legal arguments, and determines whether the judge made an error. This is why preparation at the immigration judge level is so extraordinarily important. By the time you reach the BIA, the opportunity to present evidence, to bring witnesses, to build your case, has largely passed. The appeal process is about legal review, not about getting a second chance to make your case from scratch. If critical evidence wasn't presented to the immigration judge, if important witnesses didn't testify, if legal arguments weren't properly preserved in the record, those gaps become very difficult to remedy on appeal. Now, historically, the timeline for filing an appeal to the BIA has been 30 days from the date of the immigration judge's decision. That's 30 days to make one of the most important decisions you'll face: whether to appeal, what grounds to appeal on, how to frame your legal arguments. But the landscape is shifting beneath our feet. There has been discussion within the Department of Justice about reducing this appeal filing window significantly, potentially to as few as 10 days. Whether or not such a change has been formally implemented, the direction of these discussions tells us something important about the current environment. The system is moving towards speed rather than deliberation. The default posture is shifting away from extended timelines and toward rapid resolution of cases. What does this mean for you? It means that if you receive an unfavorable decision from an immigration judge, you cannot afford to wait. You cannot take weeks to decide whether to appeal. From the moment that decision is issued, the clock is running, and whether you have 30 days or 10 days or something in between, that time will pass quickly. You need to be in immediate contact with your attorney. You need to be discussing appeal strategy before the decision is even issued, not weeks afterward. Let me talk about what happens during an appeal to the BIA. When you file a notice of appeal, you're telling the BIA that you believe the immigration judge made a legal error, and you're asking them to review the case. You then file an appellate brief, which is a written legal argument explaining what errors you believe were made and why the decision should be reversed or remanded. The BIA reviews your brief, reviews the record from your hearing, and issues a decision. That decision might affirm the immigration judge, meaning they agree with the judge's ruling. It might reverse the decision, meaning they disagree and rule in your favor. Or it might remand the case, sending it back to the immigration judge for further proceedings or for correction of specific errors. But here's where things get more complicated. The BIA has considerable discretion in how it handles appeals. Some appeals receive what's called single-member review, where one BIA member decides the case. Some receive three-member panel review. Some appeals are decided with full written opinions explaining the reasoning. Others are decided through summary affirmance, where the BIA simply states that it affirms the immigration judge's decision without detailed explanation. And in some circumstances, appeals can be summarily dismissed, meaning the BIA declines to reach the merits of your case at all. The authority for summary dismissal exists in various forms. An appeal might be dismissed as untimely if it's not filed within the required timeframe. It might be dismissed for failure to state a cognizable legal claim. The standards and procedures for these dismissals are set by regulation, and those regulations can change. What's important to understand is that filing an appeal does not guarantee that your case will receive full appellate review. The quality of your appeal, the strength of your legal arguments, the care with which the record was developed at the immigration judge level, all of these factors influence how the BIA will handle your case. This brings me to a critical point about legal representation. Immigration court is one of the few areas of American law where you can face serious legal proceedings without a guaranteed right to government-appointed counsel. If you cannot afford an attorney, the government is not required to provide one for you in immigration court. You have the right to be represented by an attorney at your own expense, and you absolutely should exercise that right if you possibly can. The difference between proceeding with an experienced immigration attorney and proceeding without one can literally be the difference between remaining with your family in the United States and being removed to a country you may not have lived in for decades. An experienced immigration attorney understands how to build a record at the immigration judge level that will withstand appellate scrutiny. They know what evidence needs to be submitted, what testimony needs to be elicited, what legal arguments need to be preserved. They know how to draft an appellate brief that clearly identifies errors and presents persuasive legal arguments. They understand the procedural rules, the filing deadlines, the technical requirements. If you're in removal proceedings and you don't have an attorney, finding one should be your highest priority. There are non-profit legal services organizations, pro bono programs, and low-cost legal clinics that may be able to help if you cannot afford to hire private counsel. Now let's talk about what happens if your appeal to the BIA is unsuccessful. Does that mean your case is over? Not necessarily. While the BIA is the end of the administrative appeals process within the immigration court system, there is another level of review available: federal court. If you believe the BIA made a legal error, you can file a petition for review in the appropriate Federal Circuit Court of Appeals. This is a different kind of review, conducted by Article 3 federal judges rather than by administrative officials within the Department of Justice. Federal courts have the authority to review whether the BIA's decision was supported by substantial evidence and whether it correctly applied the law. This judicial review is important because it provides a check on the administrative process. It ensures that constitutional rights are protected, that immigration laws are correctly interpreted, that agencies don't exceed their statutory authority. However, federal court review is also limited in important ways. Federal courts generally cannot review factual determinations if they were supported by substantial evidence in the record. They cannot substitute their judgment for the agencies on matters of discretion, and there are strict deadlines for filing a petition for review, typically 30 days from the BIA's decision. Beyond appeals, there are other procedural mechanisms that may be available in certain circumstances. A motion to reopen asks the immigration judge or the BIA to reconsider a case based on new evidence or changed circumstances. A motion to reconsider argues that the decision-maker made an error of law or fact. There are strict requirements and deadlines for these motions, but in appropriate cases they can provide a path to relief. Additionally, you can request a stay of removal, which is an order temporarily halting your deportation while appeals or other legal proceedings are pending. Getting a stay is not automatic and requires showing a likelihood of success on the merits and irreparable harm if removal proceeds. I want to address something that weighs heavily on many people: the feeling that the system is moving too fast, that the timelines are too compressed, that there's not enough time to get everything right. Those feelings are valid. Immigration court has always been a system under tremendous pressure, with large backlogs, overworked judges, and complex cases that deserve more time and attention than they often receive. When policies shift toward faster case processing, when appeal windows potentially shrink, when there's institutional pressure to clear dockets quickly, that pressure is felt most acutely by the individuals whose lives are being decided. But here's what I want you to hold on to. Due process still exists. The right to a hearing, the right to present evidence, the right to legal representation, the right to appeal, the right to judicial review. These rights remain. They may be exercised within tighter timeframes. They may require more immediate action and preparation, but they have not been eliminated. The Constitution still applies. Immigration law still operates within legal constraints. Courts still have the authority to correct errors and protect rights. What this compressed timeline means practically is that you cannot afford to be passive. You cannot wait to see what happens. From the moment you receive a notice to appear in immigration court, you need to be taking action. Find an attorney immediately. Begin gathering documents that support your case, evidence of how long you've been in the United States, evidence of your family ties here, evidence of hardship you would face if removed, evidence of your good moral character, any paperwork related to your immigration status or applications. Keep everything organized, dated, and in a safe place. Make copies of everything. Attend every single court hearing. If you miss a hearing, the judge can order you removed in absentia, meaning in your absence, and you'll lose the opportunity to present your case. For moved, update your address with the court immediately. If something prevents you from attending a scheduled hearing, contact your attorney right away to see if the hearing can be rescheduled. Understand that executive orders and policy changes from the administration can influence how immigration enforcement is prioritized and how cases are handled. But they don't rewrite the Immigration and Nationality Act. They operate within the framework of existing law. When you hear about new enforcement initiatives or policy shifts, talk to your attorney about how they might affect your specific case. Don't rely on rumors or on general news reports to make legal decisions. Get advice based on your individual circumstances. I know this is overwhelming. I know the emotional toll of living in uncertainty, of not knowing whether you'll be able to stay with your family, of navigating a legal system that can feel impersonal and rushed. That emotional strain is real, and it's okay to acknowledge it. But I also want to encourage you to channel that anxiety into preparation. Use it as motivation to get organized, to find legal help, to understand your rights. Informed action is always more powerful than fear. This video provides general information about how immigration court proceedings and appeals typically work. It is not legal advice for your specific situation. Every case is different, with its own facts, its own legal issues, its own procedural history. What I've shared today is meant to help you understand the system so you can have better conversations with your attorney and make more informed decisions. But the only person who can give you advice about your specific case is an attorney who has reviewed your file and knows your circumstances. The immigration court system is going through a period of significant change. Procedures that seemed settled are being reconsidered. Timelines that once provided breathing room are being compressed. The institutional focus has shifted toward efficiency and speed. This is a fundamental change in how the courts operate, and it requires a fundamental shift in how cases are prepared and defended. The time when you could wait until after an unfavorable decision to start thinking about an appeal, that time has passed. Strategy needs to begin earlier. Preparation needs to be more thorough. Action needs to be more immediate. But through all of these changes, remember this: you have rights. You have the right to your day in court. You have the right to be heard. You have the right to present your case. Those rights still exist, and they're worth fighting for. If you're in removal proceedings, don't face this alone. Find an attorney, get organized, act quickly, and remember that while the landscape is shifting beneath our feet, understanding these changes is your first line of defense. If you found this information helpful, please share it with others who might benefit. And if you have questions or experiences you'd like to share, the comments are open. We're all navigating this together. And sometimes just knowing you're not alone makes the burden a little lighter. Take care of yourselves.